Guys, my name is Vijit Singh and I'm a legal intern at LEXIS and Company. Today I'm here to explain what is bail and what are bailable and non-bailable offences. So, bail is the entrustment of the accused to his sureties who are bound to produce the accused in front of the court whenever required. Bail means the security taken from a person to appear on a fixed date before the court. Bail is the release from custody of a person charged with an offence on that person a signed undertaking that he will appear in court to answer the charge. Now, the purpose of the bail is to secure the presence of the accused on the trial while allowing him his liberty and protecting him from any unnecessary detention. It must always be kept in mind that an accused is innocent until proven guilty. When deciding to grant bail, any amount of bond, the number of sureties, or conditions imposed should only be sufficient to ensure that the accused attends the next hearing. Modern bail system evolved from a series of laws originating in the Middle Ages in England. In India, bail laws are covered under the Criminal Procedure Code of 1973, that is the CRPC. However, there are also some special laws relating to offences under narcotics and drugs, terrorism, and other unlawful activities, which are stricter provisions for the grant of bail to an accused or a suspect of a crime. So, under CRPC, there are two types of offences that are mentioned. The bailable offences and non-bailable offences. So, first of all, bailable offence. A bailable offence is an offence which is mentioned under the first schedule, or section 2A of CRPC defines it as an offence which is punishable with an imprisonment of less than 3 years or with fine only. Non-bailable offences are offences which are not specified in the first schedule, and section 2A of CRPC defines them as offences which are punishable with death penalty, imprisonment of life, or imprisonment of more than 7 years. So, there are certain conditions for the grant of bail. While granting bail, the court has to keep in mind not only the nature of the accusations, but the severity of the punishment also. Reasonable apprehension of witnesses being tampered with or apprehension of there being a threat to the complainant should also weigh in with the court in matter of grant of bail. While it is not accepted to have an entire evidence establishing the guilt of the accused beyond reasonable doubt, but there ought to always be some prima facie satisfaction of the court in support of the charge. Frivolity of the prosecution should always be considered, and it is only the element of genuineness that shall be considered in the matter of grant of bail. And in an event where there being some doubt as to the genuineness of the prosecution, under normal course of events, the accused is entitled to an order of bail. So, the process of bail. When you are accused of some crime and arrested to record your statement, some information like your name, residence address, birthplace, and charge filed against you are taken. The police officer may also check for any criminal record, if any, in the police station and ask for your fingerprints to file a case against you. The crimes that are bailable and simple, you will be allowed to apply for bail immediately. However, if the crime is a little bit complex and non-bailable, you may wait for 48 hours to claim the right to your bail, However, if the crime is a bit complex and non-bailable, you may wait for 48 hours to claim your right to bail in the court wherein you are given a hearing. Depending upon the facts of the case, the judge may decide whether or not you should get bail. There are circumstances in which grant of bail is mandatory, where a person is accused of a non-bailable offence is arrested or detained without a warrant. In such cases, the concerned police officer, if he thinks fit, shall, if such person is indigent and unable to furnish surety, discharge him on executing bond without sureties for his appearance as provided in the law. Where the investigation is not completed within the stipulated time period, according to section 57 of CRPC, that a person arrested without warrant cannot be detained for more than 24 hours. However, if the concerned police officer deems it necessary to detain such person for more than 24 hours for the purpose of investigation, he can do so after obtaining a magistrate's order under section 167 of CRPC. Where no reasonable ground exists to believe that the accused has committed a non-bailable offence, section 437 subsection 2 of CRPC entails that if it appears to a concerned officer that there are no reasonable grounds for believing that the accused has committed a non-bailable offence, but that there are sufficient grounds for further inquiry into his guilt, then the accused shall be pending such inquiry be released on bail. When court is of the opinion that there are reasonable grounds for believing that the accused is not guilty of any such offence, it shall release the accused on bail according to section 437 subsection 7 of CRPC.